Texas, and then they separated, and one of them filed for divorce. I will share with you, and I'm sure you will keep this secret, they were not the first people ever, the first gay couples ever to file for divorce here in Dallas County, and there had been divorces granted, and they're not.
Be very, very quiet. Don't tell the Attorney General.
Yeah, exactly. Somehow, and nobody knows how, somehow the Attorney General's office found out what was going on.
Well, JB was contested, where the others were usually fairly quiet and uncontested.
I'm not sure I agree with that. But
Was this the one that Judge Callahan saw?
yes. And, but whether, in any case, the Attorney General intervened and said that the Texas courts do not have jurisdiction to entertain divorces of people who were lawfully married elsewhere, whether it be Massachusetts or Canada or one of the other states. Quite frankly, their position is not totally crazy because, you know, when you go to court, you have certain points you have to prove, and the very first thing that you have to prove in a marriage, or in a divorce case, is that there's been a marriage. And so the Attorney General says, since Texas Defense of Marriage Act says that there is no marriage, you can't meet the first criteria, and therefore Texas does not have jurisdiction. That case went to the Dallas Court of Appeals after our beloved justice retired, and it was heard by a panel, and it was the panel, again within the confines of these walls, wrote a very scathing opinion and went, I think, far beyond what was necessary, but overruled Judge Callahan, and that case has now been taken to the Texas Supreme Court, where it sits. The petition for review was filed last February. The Supreme Court asked for briefs, I believe it was in August, from all sides, and briefs have been filed. As we sit here this February, it's still in limbo. The Supreme Court has neither granted nor denied the petition for review. Within the last 6 months, by the way, 2 other states have faced this issue. One is Wisconsin, one is Wyoming. Both of their Supreme Courts have held that the trial courts there, even though both states have Defense of Marriage Acts, both Supreme Courts have held that the trial courts can and should entertain divorces when people were gay couples were lawfully married in the United States.
Is that based on full faith and credit?
Yes, but I will say this, at least I haven't read the Wisconsin case, at least in Wyoming, the Wyoming Defense of Marriage Act is slightly different from the one in Texas. Texas says that we will also not recognize marriages from other states and that's not in the Wyoming, so there's a little bit of a difference, but that's the status of the law right now.
Okay, so in Texas, where we have community property, and you've got a couple that's been married in another state and they come to you, or has not been married in another state, they come to you, they've got the community property, what do you do?
Punt.
Hunt, yeah.
I refer them to Key.
Yeah.
You could ask a question that could take an entire semester.
I know.
Because nobody knows the answer to that. I wrote a brief an amicus brief in the JB case in the trial court, and I pointed out that we could do both. I mean, we could recognize the Texas Defense of Marriage Act, although I don't like it, but we could recognize it and just simply say, okay, you guys were married in Massachusetts, but after you moved into Texas, no marital property accumulated, and I think that would solve the issue. But the Solicitor General of our beloved state wrote a scathing brief in response to mine, and said that. So we don't know where it's at.
Okay, so if you've got a person that comes to you for help, he's got no signed legal agreement that divides their property whatsoever. He's contributed greatly to an asset in Texas, normally that we would call community property if they were legally married. And now his partner is splitting up with him after 5 years. Do you have to prove that he's contributed a certain amount of money and that he's owed that back? What kind of things are you looking for to present to the court to try to get part of that property back for your client?
We try to answer that this way. I apologize, I'm getting over all the allergy issues. Michelle pointed out correctly that But when they come in, when somebody comes in, and they have been in I just recently got through with one 14-year relationship, and I think you've got to divide those into two categories. The ones that were married in California, I'm convinced that of the 14,000 that are legal, 13,000 of them now live in Dallas. But either they got, that's a different, could be a different situation. But if they come in, as most of them are, and they have not had a ceremonial marriage, what do you do? The basic procedure that you follow is what's called a partition. It is a civil matter. Here in Dallas and in the bigger counties in Texas, you will have specialized family courts and civil district courts. In counties like Denton and Collin County, they're combined. But when you have your separated courts, you have to file in district court because partitions have to be in the district court. And you file usually a partition. A partition is it used to be a common law action, it's now statutory, that allows, if two people own property together, and property in both senses, personal and real, although partitions speak primarily to real property. If two people own property together, one party can petition the court to partition the real estate. And the court has very little discretion as to what to do. The court is required to partition the property upon request. Either partitioning is called in kind. If you've got 120 acres, the court can give 60 acres to one and 60 acres to another. Or if it can't be done, which is actually most of the time, like you've got a house and a homestead, then the court has to order that it be sold. It cannot order that it be awarded to one party or the other.
So if it's contested by the other party, by the other member
The
of the couple?
The only thing that can be contested is how the court divvies up the proceeds from the sale. You start with the presumption that there's a 50-50 ownership, and then and if you look at Professor Basanio's litigation guide, there will be a laundry list of what the court can take into consideration to move to give one party 80% and one party 20%. They caution that laundry list, when you get to what you can apply to the partition, the issues such as payments on the note, those are equitable issues, and the court is not required to follow those, although they usually will. But you can go down the laundry list of what some courts have done and the appellate courts have upheld. But that's where the fight usually comes in. Other things you can use. There is a little-known common law action that can be very effective, and you touched on this a little bit a minute ago, can be very effective in these cases, and it's called ouster, O-U-S-T-E-R, and that is if somebody has been unlawfully excluded from property that they have a right to be in, and there's monetary damages for that. That can frequently happens in these cases, particularly if you've got some real estate where it's in one party's name, although they've lived there together for 15 years. And so the person whose name is on the deed, the locks, it changes the locks. That's ouster, and as I said, there's monetary damages for that. I just finished one in the loss, by the way, in last fall, and there were about 7 different causes of action, everything theft, conversion, everything but assault, and it could have been that, but fortunately neither side raised it. In that case, what you can also allege is a partnership, an oral partnership, but real caution here. The relationship itself is not a partnership. The only way you can have a partnership